All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in case number JV18 0315. And is it Paul E. or Paul?
Paul C. with an E on Paul.
So is the E silent? Oh,
I believe it is, Judge.
okay. Well, Paul C. Versus DCS. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal, but if you decide to do so, I would ask that you keep the time yourself on the clock that's on the podium. The proceedings are being audio and video recorded, so if you would introduce yourself and your client at the beginning, that would be helpful. We have read the briefs, discussed the case, and please keep that in mind as you make your argument. And with that, counsel, you may proceed.
If it pleases the court, my name is John Poplick. I'm the attorney for the appellant Paul C. Judge, to start out, I think the easiest way to do this would be to see how the court got the severance in this matter. I believe it's maybe easier to get to the point by some reverse engineering. In this case, my client's rights were terminated, but the reason was how were they terminated or why were they terminated? Father was in Florida. I'm sure the court's aware of the facts that happened in here. But what happened was there was a Florida State Child Protective Services worker, and father had an ICPC done in Florida. It was denied the first time because they hadn't been to any services, was right in the beginning of the case. And then it was denied later for really two reasons, two major reasons. One was that...
Sorry to interrupt. Could I ask, when you're saying the ICPC was denied in Florida, so they take into account that there haven't been services? Are they just looking, do they just go look and see if this is assuming there's a fit parent, that there hasn't been a finding of unfitness, do they go through and look, are they saying there needs to be services at the first time?
The way I read it, Judge, the Florida, when the first ICP was put in, and it was put in a few months after the case started, the Florida came back and said he hadn't done enough services at this time, and there was a couple other reasons. His house, I think there were some windows that were sticking in his house, and minor things like that, but that's what happened at that time. Then what happened is later on, when we get 2 years down the road, there was a second ICPC requested. This had gotten to the point where there was a severance petition filed in January of 2018. The case manager came back, I believe it was around February of 2018, said that the client had completed all of his services and to their satisfaction at DCS. After that, a second ICPC went out. That ICPC was again denied by Florida in June. When this first started, the January ICPC was just based upon the issue of failure to register. After the Florida came back with the second denial of the ICPC, the petition was then amended to add 15 months time and care, and that's how the court proceeded here with the 15 months time and care. The problem is that the second time there was two purposes or reasons. One, father didn't go to the, he was at work, and the caseworker came out. The caseworker wanted a drug test. Even though father had been drug testing for a year and a half in Arizona, and Arizona had released him from the random drug testing. But the person came to father's, the CPS worker, or counterpart there, came to his work. He said he couldn't do it at that time. He didn't do the drug test at that time. He did the drug test, 2 or 3 days later, and the drug test was it was negative. The other part was there was some domestic violence allegations. It was basically that the police were called to the house 3 times in 2016. The police went out to the house in 2016. However, the caseworker couldn't find nothing on it. Basically, there was no police reports. Even 2 years later, when this trial came up, there were still no police reports regarding that. Also, our client gave a reason to the case manager.
Counsel, let me ask you. So, if termination is for 15 months in out-of-home care, then the test is what? Is whether or not the father can, what's the verb, repair, whatever it is?
Whether he can fix the, or get
whatever led to them, the 15 months in out-of-home care.
The reason was in out-of-home care, he's taking care of that. And the second part was, and father would be able to provide effective care and custody in the near future.
Right. So focusing on that first part, what is it here that kept the child for 15 months in out-of-home care?
Well, Judge, father was doing everything that they asked him to do. There was a psychological done by, the child also had some significant medical issues. He has hydrocephalitis, he has a clotting issue, and he had significant medical treatment.
But would you say that it's Florida's administrative decision that kept the child in out-of-home care for 15 months?
That's what I'm saying, Judge, is yes. Because
Yes.
we couldn't
Okay.
send him to Florida without the ICPC being granted. The child had to remain in Arizona.
So is the test then that father has to successfully deal with Florida here and eliminate that, whatever we want to call it, causal factor for the 15 months in out-of-home care? And if he can't convince them to do it, then under the written terms of the statute, then that's...
Well, I think he's got to convince Arizona, too. The Arizona is in control, even though the ICPC's done in Florida. Arizona, he worked with DCS in Arizona. He had a psychological here. He did a number of things that the state wanted to do. He came here for a visit. He went to counseling. He found his own counselors in Florida, but it was to satisfy DCS here. He did keep in contact with DCS and their counterpart in Florida. Florida came back with the ICPC, and it came back with these two issues. And if to terminate somebody's parental rights, you had to have clear and convincing evidence. There was no evidence here. I mean, basically, that the police were called to his house 3 times in 2016. There was no police reports. Nobody even knows what happened, but there was no arrest. There was nothing like that. And the second part, he had drug tested for a year and a half. She comes to his work, has him do a drug test. He didn't test. He tested a couple days later. It was negative. But there is nothing there to prove by clear and convincing evidence that he had a drug issue anymore. There's nothing to prove that he had a domestic violence issue. There just was nothing there. The problem is because Florida came back and they stated that they denied the ICPC, father couldn't get the child back with them in Florida. And if you look at it here, Judge, even the petition that was filed in January was regarding registration. Father came back, the caseworker in end of February came back and said, father did everything. Father's complied with everything to our satisfaction. Then they sent it to Florida again. Then
was there also an allegation early on, was domestic violence listed, wasn't it listed as one of the reasons?
It was listed because mother said there was something, but nobody ever found anything in all these years.
But so if the Florida caseworker had dug up some police reports that detailed something, you would agree that that would be relevant and the court could consider it?
I think it would be relevant, Judge. I think the bigger part of this is that there was no, the statute, it's got to be proved by clear and convincing evidence. That neither one of those things were proved by clear.
What exactly did
evidence.
the Florida caseworker find then? Was it just that there had been a police report?
There was 3 times that, no, there was no police report, Judge. There was 3 times that somebody was called out to the house in 2016, to father's house. And that was reported, I believe it was quite a bit later. Mom had called into CPS, said that the police had been called out to the house, and that's how it eventually came up, but it was a couple years down the road here. And if you go back to the Florida, there was no police reports, there was no arrests, there was nothing. In fact, the caseworker, I don't think, could find anything on it. But she still put it in the report that there was possible domestic violence. The key, I guess, to this is as long as the state or as Florida maintains the ICPC and denies the ICPC, father can't move ahead with anything. And the question is, is the ICPC involve parents? That's a problem. There's been a number of cases lately that are coming down in other states, and it's really to prevent the type of situation that had happened here. As long as Florida doesn't approve dad for Florida on any reason, and these were really strong reasons, dad's stuck. Dad can't get his child back. And then I think what happened here, it eventually went to severance, but was based on ICPC in Florida, and dad not being able to go back to Florida, or to come for the child being able to go back to Florida.
So is there any deference or reciprocity, I'm not sure what the right word would be, between a Florida agency's findings or conclusions and the state of Arizona's inquiry? Or is it has to be a completely independent inquiry based on evidence to determine parental fitness and services?
Well, the services and the parental fitness was the subject of the Arizona action and what was going on in Arizona. They requested from Florida to check this out to
right, but we had a social worker twice deny under this acronym ICPC. So what I'm asking you is, what does that mean in the calculus? What does Arizona, anywhere from it being a per se, yes, we have to accept that and terminate, or it's anecdotal at best, and we have to conduct our own inquiry?
No, I think the problem is under the Leonardo case. Basically, they define parents as the ICPC applies to parents. And so Florida has the right for their administrative, it's an administrative procedure, and Florida has, they're basically saying that well, basically, they say the child can't come here, and we're not going to accept him into our state.
But so, if Florida just said we don't have enough money to pay for social workers, so we are not going to, we just can't send somebody out there. What in your view happens? Can DCS just send the child to Florida without?
That's the key, Judge, on the Leonardo case and the other cases that are changing at this point. Leonardo says that there has to be an ICPC, and basically the Florida administrative person or the case manager, they basically control what happens with that. Even if the judge here, the judge has no independence, and that's part of the reason that the Florida court, or that the other courts that have changed a lot of these, where they don't include parents in the definition under the ICPC.
Are you saying that Florida administrative decision here, the single social worker's decision, is a complete bar, and it's a non-reviewable bar? No one has the authority to review that decision?
The problem is that if even if you had the court review it here, and the court reviews it and wants to change it, as long as the Florida ICPC doesn't change their mind or keeps the denial in place, there's nothing the court can do here. And that's part of the problem. I think it impinges on...
When you say there's nothing we can do, it's because of the Leonardo case. It's not because of anything in the DCS statute that fails to authorize DCS to release a child to their parent.
Well, the ICPC itself says that Arizona can't send them there unless there's an approval by Florida, and the issue is that in all these other cases, what's happening at this point is that the courts are coming down and saying that the ICPC doesn't apply to parents,
Can you give me an
to
example
non-custodial
case?
parents.
What's your best case?
That would be the Washington case that I cited, and that's
And the notion being that there has to be a finding that they're unfit. And if there's not a finding of unfitness, then there's not a basis for preventing the parent from having their child.
there's an argument that in some states, if the parent in Florida didn't do anything, and they didn't have any charges, or there's nothing that they can find, then it would be. But if there's anything there, the way that Leonardo comes down is even those parents have to comply with the ICPC. And there's been a number in these cases. Sometimes it's very minor stuff, but the problem is Florida basically controls what happens here. And if they don't change their denial, then Arizona, it's basically sending them down the road on the severance. And I don't think that's what the legislature intended, but that's what's happening.
If Father came out, if Father came to Arizona and stayed in an apartment for a month and said, I'm ready to parent my child, there'd be a basis for DCS not giving him the child?
Well, DCS, if he came out here, DCS would probably want to make sure that everything's done. But they also look at, does he have a place for the child to stay? In this case, because the child had medical needs, would he be able to?
But assuming Father were to take care of that, presumably he comes to Arizona, there's nothing, from your perspective, there's nothing in the record that would keep Father from, or there would not be a basis for severing Father's parental rights. Is that?
Well, I don't believe so, Judge, because even the caseworker, there is something in the record that she said he completed all the services and that did everything he could at that in Arizona.
And then if he were to just move back to Florida 2 months later, there wouldn't be any supervision by anybody, presumably?
I don't believe that there may be a well, Arizona's going to keep track of it for a little while because of the medical needs of the child and some of the allegations that were made. They're going to keep track of it.
Keep track
to
of
make
it
sure
if
everything.
It's apparent?
Well, usually what they do is he'll go back to Florida. Florida will monitor it for a couple months, and then everything's gone, and they'll take care of it that way. But the big situation, I mean, basically here with the ruling in Leonardo, almost every parent has to be brought into this, no matter what. If that other state turns around and they deny the ICPC, then you can't move forward with the case. And here, even the judges, even if the judge looks at it and says, no, I don't think there's enough there, he could go back with Dad, you can't do it because of Florida. And that's caused this case to go down the line where, I mean, here's a child that never know his dad, and his dad's not going to really know him. And, you know, parents in these cases, all their arguments are, foster care. We look at agencies and all these things. There's no real definitions in ICPC which really governs parents. And parents really have a constitutional right, which puts them, I believe, over all of these agencies or these organizations that needs to be helped and protected here. And what's happening here, even the Arizona judge can't say, I want to send him to Florida anyways, because I don't believe that's a problem, and we can't do that. It's precluded.
Can we address this? Sorry to interrupt, but can we address this without saying we have to disagree with Leonardo? If we were to simply say something new came up in Florida with the second ICPC, but it seemed to have come up only weeks before the petition and the hearing. Presumably, Father should be given an opportunity to rebut, or if there's some problem, services should be offered. Is that a way to harmonize this without saying we need to revisit Leonardo?
Well, I think Leonardo needs to be revisited. And the reason it's either we do away with Leonardo, uphold Leonardo, or somehow distinguish it. I think the judge here needs to have something available to him if he looks at the case and say the other state is wrong, they didn't do anything, so that he doesn't have this type of result. And these types of results are happening in more places, and that's why Texas just, or it was New York, just filed or came up with a case in March of this year. There was one in Delaware. There's another case in Washington that I cited in this case. But the bottom line is, unless something changes here, these things are going to happen again. And this is an outcome that shouldn't happen. This little girl is not going to never know who her father is. When she's 18, she's going to probably wonder what happened here. But it basically comes down to a Florida caseworker denied the ICPC, and we ended up in severance, and her rights are terminated at this point. I'll reserve the rest of my time that I have left. Thanks.
Thank you. Counsel.
Thank you. I'm Michelle Nimmo. I'm with the Attorney General's Office, and I'm here on behalf of the Department of Child Safety. To get, I think, to the heart of the matter, Judge, you asked, was it Florida's administrative decision that led to the termination of parental rights here? And the answer is no. It's not the denial of placement in Florida that provides the evidence for a ground for termination in Arizona. The underlying reasons why Florida denied placement can supply, and did in this case, supply evidence to satisfy.
But so what are you saying makes him an
Arizona
unfit parent based on the whatever Florida concluded?
Sure. So at the inception of the case, mother alleged that father had been domestically violent with her during her pregnancy. She said he hadn't hit her in the stomach, but he had hit her in the face and put his hands around her neck, and that she had twice called the police. So that was one issue, was domestic violence.
The DCS removed that as a basis, didn't they?
Not exactly. So those claims were not corroborated at the inception of the case. And so at some point, DCS initially did put domestic violence in the case plan, but at some point during the progression of the case, because mother, who was substantially troubled and essentially, wasn't in touch with the department and was not available, and because in the first ICPC it didn't turn up information that became known in the second ICPC, there was a discussion about that, and so DCS did relent and removed that because it didn't have...
Discussion about what?
Removed domestic violence as an issue that he needed to address. Because at that time in the case, it was uncorroborated. However, it's not that Florida came back with something new at the time of the second ICPC. It's that Florida identified these contacts with law enforcement that mother had made that corroborated her initial statements. They were in August of 20. Well, two of them were in August of 2016.
So we have a standard, clear and convincing, and so let's start building the case. The first is an uncorroborated complaint against father that was later dismissed, at least as a service issue, from DCS. The second is Florida finding new reports.
Florida finds old reports. That corroborate mother's initial statement. So mother initially said, I came to Arizona because he has become domestically violent with me, and I am pregnant, and I'm afraid.
But is there a report
and
from
there's
Florida?
Also, in Exhibit 11, there are, one of them contains somewhat of a narrative. It's the one that refers to father being so distraught over the breakup of the relationship that he says he wants to put a gun in his mouth, and he's apparently transported to some kind of facility. Later in his psychological evaluation, it appears he overcomes whatever that intense incident is. And it's not, I shouldn't say that it's that mother's statements were entirely uncorroborated. father admitted that they had issues and that he had been heavily drinking, like 12 to 18 beers a day. So during that time when they were fighting, so he denied the violence.
He denies the violence, and mother never comes and testifies that he's been violent. So
Mother was not available.
So what? There was just some statement from earlier alleging that was the reason. That was the reason that she came to Arizona, but no testimony, no sworn statement from her ever. We're saying this is clear and convincing evidence of domestic violence.
Well, it's one factor in a totality of evidence.
Well, but do we have? I guess the basic question is: there clear and convincing evidence of domestic violence?
The juvenile court found there was clear and convincing evidence that father had failed to remedy the circumstances that caused the child to be in out-of-home care. I don't think that's limited to one circumstance.
Okay, but your answer to that, would you agree that there's not clear and convincing evidence of domestic violence? And
I think that's not what the issue that was before the court.
Okay, but then let me ask a follow-up question. If the issue is just there's a concern about it, would you agree that there needs to be an attempt to provide services? What's the attempt to provide services?
So the domestic violence was linked to another central issue in the case, which was father's substance abuse. Father admitted that he had been, and he told the psychologist that he had begun heavily drinking as young as 21 or 22, would drink 18 beers a day. He had a historical DUI.
Let me stop you right there. You said that wasn't before the court, whether or not it was corroborated or whether or not that was clear and convincing evidence of domestic violence. Wasn't that precisely what was before the court?
Well,
because if they made that finding, it was the end of the show. So I guess I would repose Judge Catani's question. Is it the state's position that on this record there's clear and convincing evidence of domestic violence?
It's the state's position that there's clear and convincing evidence that there were circumstances that caused this child to be placed out of the home and that father had failed to remedy them.
Yeah, but let me follow up, though.
There weren't services provided to address domestic violence. So.
Okay, but let me just follow up. Let's say the basis for the denial in Florida is father is Hispanic, and we don't think single Hispanic fathers can raise a child, can raise a little girl. And we're not going to sign off on an ICPC. Would that be a basis for severing father's rights?
No, because there's not a ground in Arizona that supports a finding.
But you're saying it's 15 months time in care, and Florida is saying we are not going to approve the ICPC because we don't think single Hispanic parents can raise a child. That's still 15 months time in care. And how is that different from if we're saying here that if you're sort of acknowledging that there isn't clear and convincing evidence of domestic violence, and if that's what Florida is relying on, where does that leave father?
Well, I disagree that Florida, so under the analogy you're using, being Hispanic is not, in Arizona, a ground for termination of parental rights. Domestic violence, for that matter, isn't a ground for termination of parental rights. The inability to provide proper and effective parental care and control and the placement of your child out of the home for an extended period of time can become a ground for termination of parental rights, and that's what happened here. But it wasn't domestic violence alone. So I don't mean to be evasive about domestic violence. What I mean to say, so substance abuse was a central issue in the case from the very, very beginning.
Didn't DCS sign off and say he's done everything he needs to with substance abuse?
So he did at some point complete services. It's not accurate that he tested for 1.5 years. He tested for a period of a few months. He did complete the services that had been identified in Florida. And compliance with the case plan is obviously a positive, but what the case manager testified to is that Arizona doesn't just look for compliance with a case plan and checking off a box. We need to see behavioral change.
But let's go back though. Assume father is in Arizona. Is there any basis for finding that substance abuse is a reason for severing his parental rights?
Had the DCS worker in Arizona had the same kind of interaction with the father that the worker in Florida had, then...
And that interaction just being his refusal to submit to one drug test, but then taking the drug test a few days later?
Monday and Thursday?
It was about 4 days.
That would be
I believe
clear
it was
and
4
convincing
days.
evidence of substance abuse when you test negative 3 days later and had otherwise complied with everything that DCS had requested that he do?
It's not the most compelling evidence of substance abuse, but everything has to be considered in together. So we need to
So
look
we
at
have
this
the-
particular
The
child.
test is whether or not the father has been able to remedy the circumstances. So you keep talking about the totality of circumstances altogether, but in order to determine whether there has been an effective remedy of the circumstances, we actually do have to look pretty specifically at what are those circumstances and were they remedied. So can you walk us through that very clearly? What are the circumstances and what is the clear and convincing evidence of failure to remedy each of those circumstances?
So the child is severely medically compromised and needs a parent who will be affirmative and on top of things and ready to address his needs. This father was described as often minimizing his needs, not really seeming to understand that. When he testified at trial, he said, "I'll be bringing the child to work with me. It's okay with my boss." This is a child who's paralyzed on one side, who has multiple appointments. He's followed by a neurologist, a physical therapist, an occupational therapist. And this is the same location, his place of
But I
employment.
go back to, if he were in Arizona, would that have been a basis for severing parental rights?
The child is in Arizona, and an Arizona court did make that finding.
No, but I'm saying absent, let's say we didn't have any testimony, there wasn't an issue with a Florida social worker saying, I'm not going to sign off on an ICPC. It seemed to me from the record that DCS was willing to sign off at some point, and the only thing they were waiting on was approval from Florida. Is that not accurate?
I don't think that's entirely accurate. There was a motion for termination pending, and the case manager testified, actually the supervisor testified, that even if the ICPC had been approved, that wasn't an automatic placement with father. This child would have to be transitioned, and safety precautions would need to be put in place because he himself.
Okay, but that's
has
different than
needs.
saying there's a basis for severing rights. It's just talking about transitioning. You have to find a base. You have to find something that demonstrates unfitness. Again, I'm assuming that the child is just in Arizona. Would there have been a basis? I understand there can be a transition period, but would there be a basis for severing parental rights if he were in Arizona and we didn't have a report from the Florida social worker?
Well, assuming that everything that happened in Florida happened in Arizona. So we're assuming that father is here and all of the facts are
And so everything that
equivalent.
happened in Florida was he refused to take one drug test. What else happened in Florida that demonstrates that he's an unfit parent?
Father did not take advantage at all times of the opportunity to visit with his child, did not establish
Was that just in-person visits, or did he not make
both.
enough?
He did not. He had liberal allowance to call the placement and did not take full advantage of that. Sometimes there's testimony that he would go sometimes a month or so without being in contact. There's also some testimony that he would sometimes be in touch and say that he was having trouble reaching the placement. So that was a little bit
it's your
mixed, but the
position that
juvenile
if he'd
court
been in-
resolved it in favor of the
It's your
department.
position that if he'd been in Arizona, that his rights could have been severed based on needing to make more phone calls or needing to make more in-person visits?
I think, again, there's sort of a whole picture that emerges of the parent. So he has a history of substance abuse, which seemed to be resolved, but then when there was a subsequent interaction with him after the fact, he didn't demonstrate the behavioral change that substance abuse treatment was intended to achieve.
What's
And he
that?
didn't-
Is that the Monday, Thursday thing?
Well, in addition to the Monday, Thursday thing and the sort of evasiveness of the test itself, right, because they were there, he also was unable to articulate a recovery plan. That was something that was in his treatment plan at Affinity, and it said that he had accomplished that. But when the ICPC worker asked him about that, he was unable to articulate that. It was in his treatment plan that he would attend AA meetings, and he did while he was at Affinity for those few months. But then he told the ICPC worker, I don't like the
Hadn't
meetings, I
DCS
don't go to
said
them.
that we're satisfied with the efforts regarding substance abuse?
And that is what precipitated the ICPC investigation.
Okay, but so if
And then
there's
the
something
ICPC
new,
investigation
if there's
brought
something
us
new
to
in that
the-
ICPC, again, I'm just saying,
Right.
let's say he's here in Arizona, and an Arizona social worker goes out and decides, you need to take a drug test, and he refuses, and 2 days later. I mean, if DCS is now going to assert that you have a drug problem, is there some obligation to say we need to provide services? We've previously told you substance abuse is not an issue. Now we're saying it's an issue.
That happens quite frequently, frankly,
Do
in
they
Arizona
provide
cases, right? Because
services?
you have parents who have
when
a
it happens-
substance abuse addiction and they relapse, and so sometimes there are interruptions in cases where a parent's doing well and then they falter.
Let me
and
ask
if they
you,
falter right before
let me ask you,
severance,
if somebody falters, if we're going to call this faltering, does DCS reinstitute services? I'm assuming he's in Arizona.
well, it depends, but if an extended period of time has gone by and the parent has been given that opportunity, the out-of-home placement grounds allow DCS to pursue
And
termination.
the only grounds here being that he couldn't state what his treatment plan would be, and that he denied or that he refused to test on Monday but then tested on Thursday.
Well, that he had an admitted history of substance abuse, that the psychological evaluation, which is appended to Exhibit 4, stated that he was someone who would need, if the child were to be placed with him, would need to be monitored for a period of years. That's what the psychologist recommended, even with treatment. So this was someone who had done a short period of treatment, and that's commendable and positive, and the case was moving in a good direction. But as is often the case in in-state dependencies, new information can come up that can change the complexion of the case. And so,
Well, we don't have to talk about new information, some sort of undefined. We know particularly what this new information was, and it was a 4-day delay in taking a test and apparently not filling out. Is it a form, or is he supposed to author this plan from scratch? What does that entail?
so typically they would articulate some kind of plan. So a support person, for example, he was supposed to have an AA sponsor. That was another thing he had.
Right.
It had
What's
been
in
told
this
Arizona.
plan?
So a plan. Well, he didn't have one that was articulated.
But
So
what
we
is-
don't
what is
have
in
it.
the-
So the kinds of things that recovery plans might include is someone that they call if they're going to relapse, if there are triggers of their substance abuse, ways to avoid
So like
that.
a contact.
So
Okay.
So
we
that
have 4
sort of
days
thing.
and a
I'm not an expert
contact.
in support plans, but I would point out as well that he said he didn't have a sponsor, which he was supposed to have had under the plan, and which had informed DCS's position about the progress of the case, and that he was instead relying on his boss. His boss, of course, is the person who went and whispered in another room to avoid him having to be accountable to take random urinalysis.
This
tests.
is
So he
this is
didn't have a random
significant enough for termination.
The juvenile court found that, Your Honor. I see that you are skeptical, and that is one path in this case. If the court doesn't want to address Leonardo, and I don't think it does need to. I really think that this case rests on determining, was there substantial evidence to support the juvenile court's findings, or was there not substantial evidence to support the juvenile court's findings? The department's position, of course, is that there was.
But what if there's, even assuming there were, let's say he never took the second drug test, or he just refuses on Monday. I mean, if it's now a concern, could we also say there should be, services should be provided? If it's now a concern, shouldn't he be on notice before his rights are severed? If he's been told ahead of time that substance abuse is no longer an issue, when it becomes an issue, don't you need some kind of notice and an opportunity to correct it?
They do need notice, and he had notice from the very, very beginning of the case. It's in every single court report.
Right,
that
but
one
after-
of the expectations
when
that he would
DCS
maintain,
drops it.
that he would obtain, and I apologize, Judge, but that he would obtain and maintain sobriety. So it's not that they drop it and say now it's okay to abuse drugs. That's not what dropping it means. It means you've completed right. We're on a path to complete services and hopefully achieve reunification. If the parent continues on that path and sustains the behavioral change, then that's a case that leads to reunification. But if the parent stops and starts or completes something but then engages in the very behavior that they attended treatment to no longer engage in, then that happens all the time. That's an out-of-home placement fact pattern. That's very common. And the court can, at some point, draw the line and say, we've spent enough time trying, and...
What is the evidence that he engaged in the very behavior at issue? What is the clear and convincing evidence of not just a lack of a plan, not just one failed or one missed test that he then passed successfully very shortly thereafter. What is the clear and convincing evidence that he was engaging in this behavior?
Well, that's the evidence that's in the record, is the psychological evaluation, making it very clear that he minimizes the significance and the severity of his chronic substance abuse problem, that his chronic substance abuse problem is something that will impair his parenting. That's all in the psychological evaluation. And that he is unable to engage in the very behaviors that the substance abuse treatment was intended to have accomplished. He did not, it appears he did not sustain them. And it's circumstantial, but it was highly, the juvenile court could reasonably infer that the circumstances under which he refused to take that test were very peculiar.
Could I ask a completely unrelated question? On the putative father ground, your brief didn't attempt to defend that at all?
We're prepared to concede that ground. There was a finding that paternity had been established in the record at the hearing at which the dependency adjudication was entered against father, and John Doe was dismissed from the petition, and there's a statement in the minute entry that the parties agreed that the state would file a motion for paternity. I'm not exactly sure what that meant, but we probably should not have alleged that ground, given that there was a DNA
The court relies on
testimony.
that? You don't know that played into the court's determination at all? It listed that as one of the grounds for severance?
It did list that as one of the grounds for severance. The court relied on Mother Goose, the case Mother Goose versus Frank R., I believe. And that statute is strictly applied. It's a pretty harsh statute. Fathers have, or putative fathers have 30 days from the time they have reason to know that they are father to get on the registry in Arizona. We think that case is distinguishable on these facts, given that a superior court in Arizona did enter a finding of paternity. It's not the kind of finding that will survive the dependency. So, for example, if the court were to reverse and father were to have parental rights restored, he would still need to obtain that so that he could have a legal order that would survive the dismissal of dependency if he were someday successful at reunification. But
Thank you.
it didn't
Thank
seem
you.
appropriate.
Thank you, counsel, for your
Well,
argument.
thank you. I see I'm out of time. I apologize.
Oh, no, it's,
Just two quick things, Judge. After that drug test in Florida, DCS never reinstituted random drug tests with father through the rest of the case. And also that the father had enlisted people, a counselor in Florida, other people in Florida, that the counselor had some a child with medical problems which were similar to his, and he went to classes at the hospital in Florida, and he did things to try to be brought up to speed on the medical condition of the child. And when he came to Arizona, he met with the doctors here, and he had a lot of questions for him. Nothing further, Judge.
well, thank you very much, counsel, for both of your arguments. We will take it under advisement, and with that, we are adjourned.